And on behalf of Judge Bennett and Judge McBrayer, I'm pleased to welcome Mr. Smith and Mr. Sir to this oral argument, which we are live streaming for the benefit of the public. We will conduct the hearing in the same fashion as if all of us were in the courtroom together. And each of you have 15 minutes, of which Mr. Smith has saved some for rebuttal. Unless there are any announcements, we will ask Ms. Dempsey to call the case.
Brianne Marie Baker versus Kenneth Dean Baker.
Mr. Smith, you have the floor.
Good morning, Your Honors. May it please the court, Greg Smith of the Montgomery County Bar. I am requesting 2 minutes for rebuttal.
Very good.
This is a divorce case that, as with many cases in Clarksville, has worldwide aspects on it because of the military. This case basically doubled as a Hague case and a custody case out of Germany and Nashville along with this one. That's where the issues before the court are today. There are 3 issues: whether or not both parties got full credit and deductions for support alimony issues. Second, whether or not this court or the lower court should have awarded attorney's fees for the Hague case, and then whether or not excessive fees were ordered in this particular case. As to the child support aspects, in this particular case, the trial court gave an imputed income to the wife of $1,500 a month, gave an income to the husband of around $8,300. The problem was military retirement of $1,300 a month comes out of husband's side and goes to wife's. That was not credited. The issue for that is husband's income should have went down, wife's should have went up. There are also issues that did not get credited, such as health insurance that the husband's paying, TRICARE for life, issues in regards to braces that the husband's paying. We believe this case should be remanded back to address those issues. Also, the wife testified that she had previously made $9 an hour and was about to start a job at $12.74. She had not started that at the time of court, but she said that it was in the makings. Either way, if you calculate her income at $9, it puts it about $60 higher than what the court imputed. If you calculate it at $12.74, which is what she testified to, it puts her income at about $22. Either way, whether it's $1,500, $1,560, or $2,200, you should increase the amount of her support and income by 13 because of the military retirement. Now, what happened was the court had said, and is very common in Montgomery County, DFAS, Defense Finance Administration Services, will set up an automatic allotment so that my client, the husband, never sees the money on retirement. It's a property settlement that goes deliberately from DFAS, which is in Cleveland, to the wife's account. The trial court, as is common, said until the allotment begins, consider if the DFAS has not paid it to be alimony, just simply to make sure she gets her $1,300. So as the court was ordering that, they were doing it as a fail-safe, just simply to make sure that the $1,300 didn't have a lag time, not that it was different from the property settlement. The court made clear the intent was the military retirement. That being said, Appellee has argued that the Goshrashi case, and I'm sure I just butchered that name, I apologize, but basically that case eliminates the issue here. That's not correct. That particular case talked about speculative future potential dividends. This is a set amount, starts at a certain time, automatically goes, and started from day one. For support purposes, this case should be remanded back so the court can address those issues. If there's no questions on that one, I'll go to the Hague case.
Yeah, Mr. Smith, before you leave the child support issue,
Yes, sir.
if looking at the child support worksheet in the record,
Mhm.
can you point to the spots in the form that you say need to be changed to rectify what you say should have happened? I mean, and the reason why I ask that is obviously there's a line for gross income, and I'm assuming you're not saying the gross income line should be changed, but rather there should be a deduction somewhere else in the form. And I was wondering if you could point to the form to show us where that needs to happen.
Okay. No, actually, it is gross income that I'm looking
Okay,
at.
it is. Okay, you're saying the gross income number
Right,
should have
but-
been adjusted in the form. Okay, all right, thank
So
you.
that his income goes down by 1,300, but he wasn't given credit for that reduction. Hers
see.
goes up 13. She wasn't given credit. So
Okay,
what happens is it does a false positive when you run the numbers, because you're looking at her at about 1,000 to 1,500 low, him about 1,000 to 1,500 high.
I follow.
Now-
So your position is that the mistake happened in line one, basically, at the top
Right.
line.
Now,
Okay,
there were further on down in the income, as I say, in the deductions, health insurance should have been credited. There was testimony about that. They didn't give a specific number. I'll agree to that. But he did testify, I'm covering TRICARE for life. Also, he's paying for braces that he's the only one paying for. Those numbers should have been credited, just like a daycare number should have been credited if they had daycare. Did I answer your question, sir?
you did. Thank you.
Okay. Now, as to the Hague case, this was an unusual scenario because a custody case, my client was, and the wife was deployed to Germany. My client got wind that the wife was about to leave and take the children. He files a custody case in Germany. She gets served. She leaves anyway. So a Hague case is filed in Nashville, Tennessee, heard and decided by at that time, Chief Judge Kenneth Sharp. Judge Sharp made rulings on all the issues. They had a full-blown hearing. And ironically, the only difference between the attorneys in that case and today, I'm doing the appeal. Mr. Sir, who represented the wife, was the attorney for the Hague case, the attorney for trial, the attorney for this appeal.
Is there any suggestion that it was not within the realm of reasonable choices to file this Hague case?
Your Honor, there was some argument about that, but you have options. The option on a Hague case, you can file in state court, you can file in federal court, or there were suggestions that he could get what's called a compassionate reassignment. The problem was, when asked about that specifically, he testified that he tried to and could not get the compassionate reassignment. The argument was, oh, it's easy to do. That's not easy to do, but the testimony was, he said, I tried, I couldn't get it. So with the Hague case, both parties testified they spent about $50,000 on the Hague case.
And how did Mr. Baker fund his portion of the Hague? Did he use credit cards or what?
He used
what
credit cards and loans. It's my understanding, yes, sir. Because
how did that debt get allocated in the division of assets?
it got allocated. He paid his own way on that one. So that debt, he's covering his own debt. The issue here was that the wife testified, as did the maternal grandmother, that she borrowed money from her parents. The issue, though, is the trial court in this case made a finding that the Hague case was wasted, dissipated funds. The problem is Chief Judge Sharp found that the prima facie case justifying a Hague case was made, that there was justifiable reason to file it. And he did not award attorney's fees. Now, it's unusual to get attorney's fees in a Hague case, but it's not impossible. And interestingly, under Federal Rule of Civil Procedure 54D, the very basis that was argued at the trial level, in this case, could have been argued there, that if it was a bad faith argument, the problem was, and the reason it wasn't argued in the Hague case, because Chief Judge Sharp made a specific finding that it was a justified filing. So if there was going to be a request for attorney's fees, that should have been done on Broadway in Nashville, not at the courthouse in Clarksville 2 years later.
Mr.
So-
Smith, can't it be a justified filing, but still a waste of marital assets if other less expensive alternatives were available?
In this case, respectfully, Your Honor, I don't think so. Because of res judicata collateral estoppel, that question could have been asked to the federal court. And at that point, it could have been asked, it could have been argued. But once Chief Judge Sharp made his ruling and that wasn't appealed, that becomes res judicata. They can't go turn around 2 years later and make the exact same argument that they abandoned in front of the
But
federal court.
Aren't the factors of determining whether a Hague filing has met the prima facie requirements versus whether the filing of it was a dissipation of assets? Aren't those two different things?
Respectfully, I don't think so, because although you may call it different on semantics, you could have made the request for attorney's fees on the exact same ground of a bad faith filing or whatever in federal court. The issue is not could it have been argued, it could have, it was just argued at the wrong place at the wrong time. And by the time it was brought up, the time had passed. That's our position, Your Honor. Now, turning to excessive attorney's fees. Ironically, the trial court gave $50,000, which was the thrift savings plan amount that my client had, fully to the wife, specifically saying for attorney's fees because of the Hague case, and then turned around and argued $37,000 for attorney's fees in this case. The problem is the facts are identical, the counsel was identical, and in his appellee's brief, counsel says, well, here's 3 motions that I filed that were totally different. Well, that's a pretty good chunk. And I realized that there was obviously trial and so forth different, but $37,000 for CW3 and a wife that is unemployed, we believe is excessive. The matter should be remanded back to, one, determine what was overlap learning, because the learning curve, clearly it was the exact same facts, the exact same issues, the exact same parties and witnesses. The Hague case and the divorce, you could have interchanged transcripts and made the same conclusions on either side. Now, in regards to the final issue that was listed in the appellee's brief, there is about a 6-page or 6-sentence request for attorney's fees for frivolous appeals. Respectfully, we do not believe this is anywhere close to a frivolous appeal, but obviously that's up to the court to make. The court has been told by the legislature respectfully to be very reluctant to order under 27-1-122. My time is about up. I'll be happy to answer any questions if the court so chooses.
Hearing none, we'll hear from you on rebuttal, Mr. Smith. Mr. Sir, you have the floor.
Good morning, Your Honors. He's correct about the 3 issues that the appellant has raised, and then the appellee has raised this additional issue about fees for a frivolous appeal. This has been a long series of litigation involving this particular father and husband, and the court was able to assess his credibility and assess his past actions. And it would be there's no abuse of discretion here that is required to be found for the child support. Her prior job was at $7 somewhat an hour. She had anticipated getting a better job, but that was speculative. The court increased her salary thinking that she could make more than $7.50 an hour. And based on her health, her mental limitations, and other factors that are specifically laid out in the findings of fact, he found what her ability would be. Now, opposing counsel, the appellant, is raising the issue that this was in the form of a division of property or military retirement and should be included as to her income and deducted from his gross income. At the time this hearing was held, there was no military retirement being sent to my client. So it was in the form of alimony in futuro that the court awarded at that time. And in that case, it's clear under the regulations that when a party is receiving alimony in futuro from one of the other parties, that is not to be included as income and is not to be deducted by the payor. So the court was correct in the facts and in the law and in the reasonableness of its opinion on this child support, because it was dealing with the facts as they existed at the time when they made their ruling. Obviously, child support is always modifiable when it meets that 15% variance rule. And if the plaintiff, if the appellant wants some relief, they can always try to seek a modification in the trial court on that.
Going back for a moment to the retirement, or you said what the judge did was, since the retirement wasn't being divided at that moment, the judge awarded the same amount in terms of alimony. Was that to change after the retirement account for her was set up?
Yes, the alimony in futuro lasts until, well, let me explain in more detail. The alimony in futuro, in a way, was to secure the, it was to last until the retirement kicked in. Now, if the retirement kicked in at $1,200, the alimony in futuro would continue in the amount of another $100, because the judge wanted my client to at least receive $1,300 from him, either in the form of the portion from his military retirement, and if that wasn't sufficient, to be made up by additional alimony in futuro. And the military retirement was supposed to kick in May of this year, and this trial occurred in November of 19. So I think I answered your question, Your Honor.
So the alimony in futuro would continue if it was less, if the retirement monthly payment, once it kicked in, was less than $1,300.
Correct.
The difference would continue.
Correct.
So would it be your position that now that we're way past May, we should remand it for the trial court to reflect what's going on currently in an order?
I don't think it has to be remanded. We're looking at what happened at the time and whether there was any error at the time. And if the if the appellant wants some relief, Mr. Baker wants some relief, he has the remedy to file it in trial court for a modification.
Well, is he at this moment, is he having, he's losing some amount of his retirement to the former wife, and is he paying the $1,300 a month alimony too?
I'm not sure on that, Your Honor. I don't have the most current situation to inform you about.
I understand that would be beyond the record, but it seems kind of relevant as to whether we need to remand or if he just needs to file a new case or what. So, okay. Thank you, Mr. Sir.
Thank you. I can go. And as far as the argument about the court awarding fees, the Hague fees, in this case, I don't know where that argument comes from. The court is clear that the court considered that expenditure to be a dissipation of marital assets and itemizes what that dissipation consisted of. And it consisted of a total of $159,000, $50,000 of which was the wasteful expenditure in the Hague case.
How do we evaluate this? Is this just with the judge's discretion, or is it do we look at it under the abuse of discretion standard as to whether that $50,000 was appropriate to award or not? Or how do we look at it?
Yes, I think it's a review of facts, which and with that review, unless it's this court, that's what it would be, a standard of review.
Do you think the dissipation statement was I mean, that's a finding of fact, which we have to review, giving them a presumption of correctness unless the evidence is otherwise.
Correct.
So if this court were to take the position that the Hague fees, filing at under the Hague Convention was a legitimate option he had, and therefore he shouldn't be penalized by paying attorney's fees for it, that would require us to overturn a finding of fact that it was a wasteful thing to do. Correct.
And even if this court were to do that, there's enough dissipation here that my client was not made whole because he was spending money on his paramour and fathered 2 children with her during.
Well, the paramour is another issue. That may be dissipation, but we're really talking about the Hague fees here, aren't we?
That's included in the dissipation, but to say that it's an award.
That's not included in the $50,000 that the court listed.
The $50,000, the court listed, its list of dissipation was $50,000 that was wasted on the Hague fees, $15,000 to Ms. Lane for expenditure.
I'm not questioning the other part. I'm just asking about the Hague fees.
Can y'all revert? Oh, okay.
But Mr. Sir, what you're saying is really we're looking at the property division, asset division anyway. And so you have to look at, even if the judge were to get the dissipation number wrong, we would still have to make a determination that the asset and liability split was somehow an abuse of discretion.
Right. Yes, it goes into the division of property question.
So there's no separate award here where the court says I'm awarding alimony and solido equal to the attorney's fees for the Hague Convention case. There's not that type of thing we're looking at.
That's exactly correct. Now, it did award fees for my time spent in this case.
Right, which is the third issue of the
Yes.
appellate here. That's different than this Hague Convention. So as I read, so the trial court basically adopted your proposed findings. And what was the total dissipation number? It was like 159?
Correct.
Okay, which included, I think, 75,000 spent on the Paramore.
Correct.
Yeah. Okay.
And as far as my fees were concerned, there was more to this case than just those motions. There early on in the case, we filed a motion to establish temporary parenting plan and to establish a temporary support order. And I also had to get prepared for this trial in May or April, and then it was continued. So I had to refresh my mind and get prepared again. So I do believe the fees were reasonable. I've identified which fees were for this case versus which fees were for the Hague case in my affidavit. So I don't think there's a injustice here that would require a reversal on that. When you look at this case in its fully and holistically, and the issues that are raised in this appeal, good argument is made, but the facts and the law don't support this appeal. And when you look at it holistically, while we didn't identify why we think this appeal should not have been filed in that section of our brief, we think when you look at it in its holistic fashion, you can see that this is an additional burden on my client to have to pay fees for this appeal, and we would respectfully request that they be awarded in this case. Thank you.
Thank you, Mr. Sir. We'll now hear rebuttal from Mr. Smith.
Yes, Your Honors. In regards to income, I believe Appellee said that it was $7.50 an hour. If you look at volume 4, page 63 to 64, lines 24 to 2, Appellee being crossed, she said she had made previously $9 an hour. In regards to whether or not the 1,300 is a property division, if you look at the final decree at pages 392 and 396, section E of the final decree for the 396, the trial court said, in the event DFAS does not pay to wife a total of $1,300 per month by direct pay as a portion of husband's disposable retirement, pay per section E, husband shall pay wife a sum sufficient to equal $1,300 per month as alimony in futuro. It was strictly a property division, and that was a backup to make sure that it got paid. In regards to the Hague Convention,
Is he paying both? I mean, what's the issue here?
At this point, One, I believe he is paying both. I'm not sure. That's something on remand that can be addressed, but either way, he's paying child support on an amount that he's not making either way. But yes, the intent appeared to be to cut it off when retirement started. There's no further order that I've seen that says that's happened. In regards to whether or not the court specifically was addressing the Hague case for attorney's fees, if the court looks at volume 3, 387, the final decree at point 5B on conclusions of law, and volume 382 to 383 final decree finding of facts 84 and 85, that specifically indicates that he was looking at that as attorney's fees. I'm sorry, I'm out of time.
Thank you, Mr. Smith and Mr. Sir, for your arguments. We will take this matter under advisement. Ms. Dempsey.
Thank you.
This honorable court is in recess until 11 a.m.
Thank you, honors.
Thank you.